Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Kemerer. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA.
Kreller has been the leader in enhanced due diligence involving FCPA compliance programs since 1988. Our boots-on-the-ground research combined with our in-house team of licensed investigators allows us to continually outperform even the most sophisticated database providers. For the past 30 years, Kreller has become synonymous with high-quality, decisionable reports that uncover hidden truths that our competitors routinely miss. Kreller also has a best-in-class case management system, Kreller Online, which allows for companies to develop and administer their own questionnaires, risk ranking scoring, and third-party training, while continuously monitoring the companies and shareholders through worldwide sanction lists.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Kemerer, and I invite you to my next FCPA Institute in Nashville on May 3rd through the 4th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash. This is Professor Mike Kemerer, and in this episode I'm pleased to be joined by Hannibal Kemerer. He's a senior attorney at Squire Patton Boggs in Washington, D.C., and previously he served as chief counsel of the Senate Judiciary Committee Crime and Drugs Subcommittee, where he was the lead lawyer for Senator Arlen Specter. Thanks for joining me today, Hannibal.
It's my pleasure, Mike. Thanks for having me.
Now, if one were to categorize the top events in the FCPA space over the last decade or so, I think almost by definition, congressional hearing on the FCPA would have to make the list in some capacity. And that's really why I wanted to talk to you, among other things, to take listeners kind of inside this moment in FCPA legislative history. And as I mentioned in the introduction, you were chief counsel to Senator Arlen Specter, who called that hearing. And from your perspective, Senator Specter has now obviously passed on, but from your perspective, what motivated the senator to call this hearing, and what do you believe he hoped to accomplish by having this FCPA hearing in late 2010?
Yeah, well, thanks for that question. Senator Specter was very much a lawyer's lawyer. He was the former district attorney for the city of Philadelphia, and by the time I met him in 2004, he'd been in the Senate for nearly a quarter century. So he also served his entire Senate service, which ended up being 30 years, on the Judiciary Committee. And the Judiciary Committee does oversight of the Department of Justice, or DOJ. And so he always tried to use those oversight hearings, like the one on the FCPA, to nudge and prod DOJ to do the right thing in the public interest. He was also a voracious reader. He read a lot of news and had come across Department of Justice press releases and articles about the Siemens guilty plea, and was very interested in that. In Siemens, there was a $1.6 billion in foreign and domestic fines and disgorgement. This happened in 2008, and more recent to the hearing, he'd also read about the Panalpina line of cases, which resulted in over $236 million in criminal fines and penalties. So those things piqued his interest, but also the dearth or the absence of any individual prosecutions for the company conduct. Senator Specter was, very much familiar with the notion that companies act through their employees, their individual employees, and I think he wanted to hold the hearing to have DOJ be more receptive to the notion that in order to get deterrence, you really need to, in white-collar cases, you really need to have individuals prosecuted.
So it sounds like his interest in holding individuals accountable, which if you go back historically, is something the Department of Justice did in the vast majority of corporate enforcement actions from 1977 to, let's just say, circa 2000. But during the time period relevant to this hearing, as you mentioned, there were several notable cases and many others in which individuals were not charged in connection with some rather egregious corporate cases. So what do you think he hoped to accomplish? You indicated that his interest was in individual accountability. What do you think he hoped to accomplish by holding the hearing? And do you think with the passage of time that has been accomplished?
Yeah, so I think a lot of good came from the hearing. I think it's fair to say that the FCPA guidebook from the DOJ and Securities and Exchange Commission could trace its lineage back to questions from Senator Klobuchar during that November 2010 hearing. I think that the Department of Justice has pursued some more individual prosecutions, and, tellingly, their interpretations of the FCPA are more likely to be put to the test in contested litigation because, as you know, most of the corporations don't contest guilt or liability. They ultimately acquiesce and sign agreements. So I think that's a good thing. I think it's good that people are contesting the interpretive guidance or the interpretations that we get from the FCC and DOJ. I mean, harkening back to the hearing, I reread Andrew Weissman's testimony where he says the primary interpretive function is still being performed almost exclusively by the DOJ fraud section and the SEC. And then he cites you for the proposition that the FCPA means what enforcement agencies say it means. Now, that was true then. I think it's less true now. We've had a number of contested individual cases, and that's better for the rule of law. Another good thing that came of the hearing is the Yates memo. I mean, maybe not a direct lineage back to 2010, but September 2015 Yates memo does talk about the need for individual accountability for corporate wrongdoing, and we think that's a good thing as well. And then finally, I got to meet you as a consequence of that hearing. I had read the facade of FCPA enforcement, and we were glad to have you come testify.
Well, it was certainly a useful experience and memorable experience at that as well. I just want to go back a little bit to the DOJ's prosecution of individuals, because when you really look at it, the DOJ's prosecution of individuals can occur in two different ways. There is absolutely no doubt that the DOJ can cite statistics as to the number of individuals charged for FCPA offenses. But the reality is that the vast majority of these individual enforcement actions are clustered in a very, very small series of cases, almost always involving small privately held companies, where in connection with one matter, the DOJ charges anywhere from like 4 to 6 individuals. And I'm just curious, was Senator Specter's, main concern just the aggregate number of individual prosecutions, or the notion that in connection with corporate actions, there were so few FCPA charges against individuals? Because since the hearing, I think the statistics are, pretty similar to the number of corporate enforcement actions that lack individual charges. That percentage is roughly 80%, I think.
Yeah, I think his concern was the latter. He didn't understand how you could have these, significant corporate resolutions involving multi-million, tens and hundreds of millions of dollars, and not hold any individual accountable. And for him, those types of prosecutions could result in just being, the cost of doing business. Nobody ever goes to jail, no one's ever gets hurt, and the fines amount to the cost of doing business. Now, I know in retrospect, now I'm in private practice and deal with these issues more directly, that the fines and penalties are only part of the picture. I mean, they're the tip of the iceberg, right? As the point you make, there's a ton of money that goes into attempting to comply, attempting to remediate, and conducting investigations, particularly when they involve outside counsel, accounting professionals, forensic professionals, people who house and store data on platforms that can be reviewed. That gets really, really expensive, and it oftentimes occurs even before the enforcement action.
Now, a month prior to this FCPA hearing, in October of 2010, the U.S. Chamber of Commerce released a white paper pushing for various aspects of FCPA reform. Most people, I would put myself in this category, just kind of automatically assumed that the November 2010 hearing was directly related to the Chamber releasing that FCPA reform piece a month earlier. Was there a direct connection, or was this timing just merely a coincidence?
It was merely a coincidence. Prior to that hearing, I was familiar with Andrew Weissman's work drafting the Chamber's white paper, and my former Judiciary Committee colleague, Harold Kim, who worked with the Chamber's Institute for Legal Reform, had socialized it on the Hill, but my familiarity with that white paper and other staff and members' familiarity with it really had nothing to do with what animated Senator Specter's desire to hold a hearing, which was to bring justice officials in and ask them about individual prosecutions.
Now, during the hearing, and the House also held an FCPA hearing shortly after. That House hearing occurred in June 2011. There appeared, if one can make conclusions from member statements and sort of read the tea leaves from member statements, there appeared to be bipartisan support for at least certain aspects of FCPA reform. Yet that never did occur. And do you have any insight or opinions as to why FCPA reform seemed to be such a hot topic in late 2010 and early 2011, but never actually happened?
I think it's very difficult in the current environment for even bipartisan legislation to get enacted. The other thing is we live in a 24-hour news cycle where members of the same party have to look over their shoulder for potential primary opponents. And so even in circumstances like this, where you had, Representative Bobby Scott and Representative John Conyers and the now chairman of the House Judiciary Committee, Bob Goodlatte, discussing reforms. In fact, they might have even introduced or proposed legislation. Even in that context, it's difficult to pass anything. And I think, there were some outside groups, nonprofits, good governance groups, who accused anyone of proposing legislation in this space as pro-bribery. It's an unfair accusation, but it's one that members are sensitive to. And so if I had to guess, and I haven't talked to any of those members about this, but I would say it was probably they were a little gun-shy after some of those press releases.
Yeah, and this has always been a problem with the FCPA, quite frankly. This reached such a fever pitch in the mid-1980s, where there were actually bills introduced seeking to change the name of the FCPA to something a little more innocuous, like the Business Accountability Act, because it's very difficult for a substantive issues-based discussion to take place when a law is titled the Foreign Corrupt Practices Act, because no matter how good faith or policy-driven a position may be, it's going to be assailed as, waving the white flag of surrender and paving the path for corporations to go on a bribery binge, which is rather unfortunate, as you mentioned.
Yeah, I couldn't agree more. I mean, it is difficult and it's disconcerting. I think we should also go back to the point that the FCPA, as I've heard you say many times, is a fundamentally sound statute. Mr. Weissman said the same thing in his testimony in 2010. But the fact that the statute and the text is fundamentally sound doesn't necessarily mean that it's perfect, right? So there are different things that might be done to tweak the FCPA and make it a little better, that also might be done to hold the enforcement agencies a bit more accountable. But I think it's a difficult thing to do in this environment.
Well, thanks for taking listeners back to sort of an important moment in FCPA legislative history. And now I want to switch gears a little bit, because you are now a lawyer in private practice with a substantial FCPA practice for several years now. When you were on the Hill, you were looking, no doubt, at various public policy considerations concerning the FCPA and related issues. And now that you're a practitioner, I'm guessing you are encountering or thinking about the FCPA in a little bit of a different way. So big picture, what's the difference in approaching FCPA issues from a private practitioner standpoint compared to your prior role as sort of a public policy standpoint?
Yeah, I appreciate that. I think one of the big differences is I'm constantly now trying to empower legal and compliance professionals in corporations with the notion that they're not just a cost center. A lot of times people in the C-suite respect the people who go out and obtain or retain business. They respect sales folks. They respect the people who actually manufacture products or deliver services. But it's difficult to convey to them the value added by having a real robust compliance program that's susceptible to feedback and fine-tuning, and that really does protect shareholder value. That being said, I think we've had some great successes there, and we've positioned our clients well so that they can convince the C-suite that they're not just a cost center, that they actually over time save the company money. I also think DOJ's enforcement has gotten to the point where, from a practitioner point of view, there's very little incentive to self-disclose. There used to be, and I've worked with colleagues who've written about, departures under the sentencing guidelines for self-disclosing and cooperating. But under the current regime, where the enforcement entities are so aggressive, we oftentimes try to get our clients to conduct their internal investigations, do the remediation, implement new policies, practices, and procedures, and then close the matter. We think that oftentimes serves them better than subjecting themselves to a DOJ or SEC microscope.
It's interesting you mentioned that, because obviously the DOJ and the SEC have been encouraging companies to voluntarily disclose for well over a decade. That was the goal of the FCPA pilot program, of course, and that was the goal of the DOJ's recently released FCPA corporate enforcement policy from last November. But your statement on that issue is completely consistent with what I've been anecdotally hearing from many other practitioners over the last several months, that not everyone's drinking the Kool-Aid here and acting consistent with DOJ guidance. They put out this guidance hoping more people would take the bait, but anecdotally, I'm hearing the exact opposite, and your statement just confirms that.
Well, beyond that, how much stock could you put in that guidance anyway, with the Attorney General saying that they're going to tamp down on the formality of guidance, and instead they're going to use actual prosecutions to help guide people. We don't put a ton of stock into guidance. I do think, and I mentioned this earlier, the 2012 FCPA guidebook from the Department of Justice and the SEC, I think it's very useful. So, if I get a call from a client about what crosses the line with respect to foreign travel, I can look at the cases cited in there that resulted in enforcement action. I can look at the declinations that are cited in there, or the decision releases. when it comes to foreign travel for foreign officials. So I think that there's a lot of helpful stuff out there. But again, when it comes to the decision point about whether to self-disclose, we're erring on the side of not doing so.
And, the problem with any guidance, including the FCPA guidance from 2012, is one, it's non-binding. And two, I think most importantly, the real human beings who wrote that guidance are no longer in their positions. And the issue is always going to be, when you have non-binding guidance, is this year's crop of enforcers going to act consistent with a policy document that they really had no input in drafting?
Yeah, that's true. It's a problem, and it's one that you have to take into consideration when you're contemplating going to the fraud section and pitching something. So that's absolutely right.
So in this being the FCPA's 40th year, I've been asking most all guests on the podcast whether you think the FCPA has been successful in achieving its objectives, which of course requires one to define what success or what different meanings of success actually mean. But big picture, what's your thought as to whether the FCPA has been successful in achieving its objectives?
Well, I mean, the fact that we have so many ongoing investigations at the Department of Justice, at the Securities and Exchange Commission, suggests that it hasn't completely rooted out, bribery or foreign bribery in particular. One measure of success, I think, would be if enforcement had reached a tipping point, so that, in the C-suite, corporate culture, tone at the top, fully embraced compliance, and any departures from the anti-bribery culture were exceedingly rare. We're not there yet, but we're definitely getting closer. And I think that one way to achieve that, and this, I should preface this by saying this is just my opinion. This is not the opinions of Squire Patton Boggs or any of our meeting clients. But my opinion is one way to improve the deterrent factor would be to do more individual prosecutions. But we've seen the DOJ get a black eye on some of those. The Afghanistan case where they couldn't convict 10 of the 22 defendants after 2 trials and ultimately dismissed all of the claims. That was a black eye, but it was an appropriate one, right? It was a sting, and hopefully they won't be doing that type of thing anymore. On the other hand, if you don't have the type of deterrence where you're taking people in handcuffs to prison, it may be viewed as the cost of doing business. And so I think one way to improve the FCPA's success would be to shift gears a little bit and do more individual prosecution.
So if you were FCPA king for the day and you could change one thing about the actual statute or how it's enforced, what would that be?
Well, to start, let me preface this by saying I am not the FCPA king. That's you.
I'm just a guy with a computer who's just talking to a guy on the phone right now. But I appreciate it.
Not at all. So I think I like the anti-bribery provisions in the FCPA. I think that there's real value for shareholders in the books of records and internal controls provisions. I like the decision release process. I think, it's time consuming, and that can be a problem for the business, whatever it is. But I think those are all very thoughtful and well crafted. I suppose I could get behind, further defining what a agency, an instrumentality of a foreign enterprise was. That was one of the different provisions that the Chamber put forth in 2010. I think that, there are prosecutions of individuals that probably shouldn't be brought to bear. I don't think that if a pharma company gives samples to doctors at a state-owned enterprise in, China or something, that should constitute bribery. I know that the Department of Justice differs from in the domestic context. They actually prosecuted Warner Chilcott and its former president W. Carl Reichel, I think, and the company agreed to pay $125 million in criminal and civil penalties. But when he went to trial, the former president was acquitted by a jury in Massachusetts back in 2016. Now, this isn't an FCPA prosecution. It was an anti-kickback prosecution. But still, it illustrates the point that, the mere provision of dinner or something like that to someone doesn't necessarily mean that you're bribing them. And that's true both domestically with doctors under the anti-kickback statute, and I think rightfully true in foreign countries. I think about all the times that I've taken clients to lunch or dinner, and it was more about relationship building than any negative bribery or guilty mind.
As I've often said, it all depends what the B word means, what the word bribery means, and it seems like there's shifting sands as to that definition. Some of these definitions may be inconsistent with case law in other areas, but it sort of is what it is when we look at it from the FCPA standpoint. And I thank you, Hannibal. Today's guest has been Hannibal Kemerer, who is a senior attorney at Squire Patton Boggs, but for most of the time period relevant to a lot of the questions talked about today, he was instrumental in the FCPA reform hearing that took place in the Senate in 2010. And I thank you for taking listeners back to that important moment in time and sharing your current perspectives on the FCPA and its enforcement.
Mike, thank you for having me on, and anytime.
Thank you.